The legal team of the detained leader of the proscribed indigenous people of Biafra, IPOB, has said Nnamdi Kanu is obligated by the Constitution to request a fair trial. They made this known at a press briefing in Abuja. Here is more on this report.
Following the incident that took place at the Federal High Court, where the detained leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, had asked Justice Binta Nyako of the Federal High Court in Abuja to excuse herself from his trial, his lawyer, Alo Ejimako, said his client had lost confidence in the court where he was being tried.
The DSS listens to our conversations. These things led to an extraordinary court order by the former Federal High Court judge handling this case that we be provided a clean room, free from secret listening devices, in order to be effective in preparing him for trial confidentially. That clean room was not provided, and the DSS continued to interdict our documents each time we go there. A defendant is entitled, as of constitutional right, to the adequate facility to conduct, to prepare his defense, and to interact with his counsel in an atmosphere of confidentiality free from any interference whatsoever.
Also, Nemeka Ejiofor noted that although the client's action was seen by many as a sign of disrespect, he opined that the court must protect the rights of anyone who appears before it.
Then you have the right to request the judge to recuse himself. And this can happen for so many reasons. There are reasons why Mazen Nnamdi Kanu had to take that very tough option of asking the judge to recuse herself. One of which is that Mazen Nnamdi Kanu believed that the judge was respectful to the Supreme Court's judgment or decision that his bail be restored. Mazen Nnamdi Kanu felt if a Federal High Court judge does not respect the decision of the Supreme Court, then there is no need standing trial before such a judge.
Meanwhile, Jude Ugwanyi says the courts can only be ready to trial a suspect if his legal team has indicated readiness.
And instead of giving us free atmosphere for a conducive trial, they are insisting on trial whereas our client is handicapped. And when we see that that is not a fair trial, we say, please give us time, we think we should do the needful. And they said it is impossible. That was why Mazen Nnamdi Kanu insisted that this trial cannot go on. Because if the federal government should consider the insecurity in the southeast and being aware that their primary responsibility is to secure the life and property of the citizens, they should allow this man either bail or give him enough room to discuss with his lawyers so as to effectively defend himself. So in the absence of all these things, I think, in my view, that Mazen Nnamdi Kanu was right to say, I need another judge. Mazen Nnamdi Kanu never said, I need a particular judge. He said, I do not want to subject myself to this particular judge, but any other judge of the High Court is okay.
Recall that Kanu spoke from the dock on Tuesday during his trial in the 7-count terrorism charge preferred against him by the federal government. While his lawyer, Mr. Aloy Ejimako, was trying to persuade the court to suspend the trial on the basis that his client was denied the opportunity to prepare his defense, Kanu sprang up from his seat and ordered him to sit down. Kanu had told the court that he had no confidence in the court anymore and asked that the judge recuse herself from his trial, having failed to abide by the decision of the Supreme Court.